Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 105 of the DWI Guide podcast. This is going to be a good one. Buckle up and get ready for some extremely valuable content today. The reason why today's episode is so powerful is that if you practice DWI Defense in North Carolina, you are undoubtedly, without a doubt, going to come across the situations that we are going to talk about today. These situations, and maybe your curiosity has piqued as about what we're about to talk about, come up all the time, and they continue to come up because they are not challenged. They actually have, I feel like, across the state started to be part of the planning process of law enforcement because they are not getting challenged. So what are we talking about? Well, today we're talking about the officer handoff. So you have an officer that is involved in initially investigating an accident. You have an officer that is involved in initially stopping a vehicle, is at a checkpoint sometimes, as crazy as this sounds, and they smell odor of alcohol or something else kind of clues them into possible impairment. And then they call for backup, right? Hey, I need some backup here because I don't know if this person is impaired or not. I need the specialist to come down. I need the drug dog, the DWI task force officer to come down and figure out if there is in fact an impaired person standing in front of me, or if this person should be able to get back into their vehicle. This happens all the time. And it has actually started to become, and again, I just from talking with other lawyers in our office, I've seen this in my own practice, but across the state, this is not only something that happens routinely, but happens intentionally with the rise of officers that are kind of DWI specialist officers or DWI task force, DREs. These officers a lot of times will give instructions to other officers that have no experience investigating DWI and tell them, look, if you come across a possible impaired driver, you come across somebody that has an odor of alcohol, seems to be showing signs of drug impairment, whatever it might be, you give me a call and I will come out and take over the investigation. So we're going to look at challenges that arise on this front primarily due to the length of time between initial stop an officer and the time that it takes a second officer to arrive. And this is just something that happens all the time. You see it all the time in practice, but for whatever reason at this point is not something that is getting routinely challenged, and it is an absolutely legitimate challenge. It's something I've been successful on multiple times in terms of taking these type of issues forward, and something that we as a defense bar across the state need to be on the lookout for and litigating. So what are the two types of seizures under the Fourth Amendment? Well, we have arrests and investigatory stops, right? Arrest and investigatory stops. And this kind of officer handoff can impact both of those things. So we're going to talk about both of them. We're going to start talking, first of all, about the investigatory stop, and then talk about arrest. So when there is we're going to kind of go over this in a broad overview. You're going to see me, if you're watching the video, flipping through a lot of pages. If you're listening on audio, you're going to hear a lot of rustling of papers because I am looking through the cases and reading the relevant sections so that I don't miss anything or miscommunicate what the case law in North Carolina and also from the Supreme Court says on these topics. So bear with me if it takes me a few minutes to find a specific section. But what we are talking about kind of in the first part of our discussion today, when we're talking about investigatory stops, is does the mission of the traffic stop get completed without additional reasonable suspicion being created before the second officer arrives? So that's kind of like scenario number one. Mission of stop is completed, whether that is, accident follow-up, or most likely scenario is issuance of a ticket, right? Somebody stopped for tag, speeding, whatever it might be, full gambit of what needs to happen during the stop has happened, but the officer senses something is amiss, believes that there is possible impairment, calls second officer. So does the mission of the stop end without additional reasonable suspicion prior to the second officer arriving? So this is kind of like a Rodriguez issue. We're going to go through that first. Second scenario is, does the nature of the interaction itself go from being an investigatory stop to a de facto arrest before the second officer arrives, thereby requiring probable cause? So no longer just reasonable suspicion analysis, but arrest has occurred, even though the officer's not said, I'm arresting you. Arrest has occurred without the appropriate requisite probable cause. So these are the two topics that we're going to be talking about. So first of all, let's look at the investigatory stop end of things. So starting with our landmark decision from the Supreme Court of the United States, Justice Ginsburg. So I'm just going to read a couple of really important, powerful sections. Again, bear with me as I flip through pages or am taking a moment to find my place. So here is the holding from Rodriguez versus United States. This is 575 US. I will have to get the, it's a 2015 case. I apologize. I've got an older copy that doesn't have the page numbers, but I know that the page numbers are up there at this point. So Rodriguez versus US 2015 case. So here's the holding. We hold that a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. A seizure is justified only by a police observed traffic violation, therefore becomes unlawful if it is prolonged beyond the time reasonably required to complete the mission of issuing a ticket for the violation. So this is our holding. This is our framework for this means of challenge. So what is the mission of the stop? What is the mission? So a couple of quotes from the Rodriguez opinion. Without additional reasonable suspicion, the officer must allow the seized person to depart once the purpose of the stop has been completed. Further on in the opinion, authority for the seizure thus ends when tasks tied to the traffic infraction are or reasonably should have been completed. This is from Rodriguez. Like a Terry stop, the tolerable duration of police inquiries in the traffic stop context is determined by the seizure's mission to address the traffic violation that warranted the stop. And Rodriguez cites Caballes. In Caballes, however, we caution that a traffic stop can become unlawful if it is prolonged beyond the time reasonably required to complete the mission of issuing a warning ticket. And obviously, I'm kind of saying the same thing over and over again, but the court really focuses on what is the mission of the stop? What is the purpose of the stop? This is from a little bit later in the Rodriguez opinion. If an officer can complete traffic-based inquiries expeditiously, then that is the amount of time reasonably required to complete the stop's mission. and that's part of the time requirement. Finally, on scene, this is the most important thing for our purposes right now in terms of mission itself. On scene investigation into other crimes, however, detours from that mission. So let's just give an example here. We've got a officer that does a traffic stop, pulls somebody over for a speeding ticket. Basically, the mission of the stop is primarily to determine if a ticket is going to be issued and to issue that ticket. Okay, that is the primary mission of the traffic stop. So what is the appropriate time frame for the mission of the stop to be completed? As I just mentioned, I just read this, if an officer can complete traffic-based inquiries expeditiously, then that is the amount of time reasonably required to complete the stop's mission. The court also says the overall duration of the stop remains reasonable in relation to the duration of other traffic stops involving similar circumstances. So this, you get to maybe look a little bit at the individual officer in terms of how long it takes them, but looking at other traffic stops involving the same circumstances, if a speeding ticket should be able to be issued quickly, then that's the time frame that it should take. If you got a rookie officer that's out there taking 45 minutes to write a ticket, that is not a reasonable amount of time. One of the Rodriguez issues that I won, stopping officer conducted the stop, basically had my client, I think, on the roadside for about 30 minutes for a second highway patrol officer to come on and do the DWI investigation. And I asked the highway patrol officer when he took the stand, how long does it take for you on a speeding stop to issue a ticket? And he, this was a very honest, but also a great answer from a highway patrol officer that's been doing it for a long time. He said about 5 to 7 minutes from the point that I pull somebody over to the point I'm issuing the ticket. It takes me about 5 to 7 minutes. So, and he'd issued hundreds of them. So it was basically like, well, that seems to be then the reasonable time frame for this to occur. And there wasn't any reason. Clearly, in that situation, in my case, the officer was not taking that long to look at anything else. So again, in terms of the appropriate time frame, one other good section here from the court's opinion is all told, 7 or 8 minutes had elapsed from the time. This is the specific facts of Rodriguez. All told, 7 or 8 minutes had elapsed from the time Strobel issued the written warning until the dog indicated the presence of drugs. So this is the time frame for how long the additional time frame was allowed. So there's no real de minimis exception for this type of stop. I mean, it's got to be, you either have completed the mission. Once you've completed the mission, there really should not be a long further period of investigation without additional reasonable suspicion. Once you've completed the mission of the stop, the encounter should end unless there is additional reasonable suspicion. Wanted to read one other section from another North Carolina specific case. So this is from State versus Reed, North Carolina Supreme Court, February of 2020 case. And so in that decision, the Supreme Court of North Carolina kind of analyzing that case through the lens of Rodriguez said that whether Trooper Lamb diligently pursued a means of investigation that was likely to confirm or dispel his suspicions quickly, during which time it is necessary to detain the defendant. So again, looking at the time frame lens, did the officer use the appropriate means of investigation to confirm or dispel his suspicions quickly, so as not to, again, use an inappropriate, too long a period of time in completing the mission of the stop. So that's what we are looking at. The only other thing to kind of consider is, well, what is the mission, in addition potentially to just issuing a citation for a traffic violation? Well, Rodriguez kind of goes through this. Beyond determining whether to issue a traffic ticket, an officer's mission includes ordinary inquiries incident to the traffic stop. Typically, such inquiries involve checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance. So again, those can be reasonable inquiries. Now, the question is the officer actually going through those reasonable inquiries? And this is where body camera or dash camera can be helpful. In your specific case is, despite the fact that those additional items might take a 10-minute total time frame versus, a couple of minutes to issue a ticket, might take 10 minutes, might take 15 minutes to do this. The question is, does the video show the officer actually doing those things? So what the officer does not get to do is basically stop somebody for speeding, smell an odor of alcohol or whatever the additional information is in terms of impairment, call for a backup officer, and then basically not do anything related to the purpose or mission of the stop. Just sit there on the roadside until the backup officer comes, not issue a citation for speeding. Not be running the tags, not be looking at the driver's license. If they're not doing anything, then that doesn't allow them to say, well, this is what was taking so long in terms of my completion of the stop was, looking at the person's license, looking at the person's criminal history, checking for outstanding warrants, looking at the tag. Is the officer actually doing all of those things? If so, 15 minutes might be reasonable. If they're not doing any of that, then basically, you're already problematically prolonging the nature of the stop. So Rodriguez is the case we want to sink our teeth into in this case. And even though Rodriguez really involves a drug dog coming on scene, very similar in our situation is the DWI specialist or task force officer or investigating officer to get onto the scene. And why are they calling for this investigatory officer to come on scene? Well, because the stopping officer does not have the training or experience to determine whether or not the person in front of them is impaired. So let's go with some simple situations, and then you all can kind of get creative in terms of whether or not your particular case involves additional reasonable suspicion. What I see most of the time where this type of a situation comes into play is person is stopped for speeding, stopped for tag light being out, stopped for a registration issue. And at the time that they are then pulled over, they respond to the blue lights, they pull over, the officer stopped them for that reason, asks for license or whatever it might be. And what do they smell? Odor of alcohol, right? Odor of alcohol. Maybe at some point during that kind of brief investigation, they also ask the person to do a PBT, and a PBT sample is given. But basically, they smell an odor of alcohol, and that is the primary basis for which they now go back to their car, say, hey, do you have anybody that's on the DWI task force or on the from Highway Patrol that can come down and investigate this person? I'm smelling an odor of alcohol. I just want to see if I can get this person checked out. Doesn't that, here's the question, here's the $1 million question, which I think too many of us don't challenge us. Here's the $1 million question. Well, the officer smelled an odor of alcohol. Isn't that reasonable suspicion of impaired driving? Answer, no, it's not. It's not additional reasonable suspicion. That in and of itself, you got a person that's been speeding, officer comes up, gets their license, smell an odor of alcohol. Therefore I can hold this person until the second officer comes because I got reasonable suspicion of impairment. Does that odor of alcohol allow for a finding? of reasonable suspicion of impaired driving, such that the stop now moves from a mission of issuing a traffic citation for taillight, for speeding, to an investigation of possible impaired driving. No, the answer is simply on that front. No, in and of itself, just odor of alcohol alone doesn't give additional reasonable suspicion. State versus Pearson, North Carolina case. This is a Supreme Court case 348 NC 272, a 1998 case, in finding that there was no basis for the continued investigation on the state's end. One part of the court's opinion says the defendant had a slight odor of alcohol, but not enough to be charged with driving while impaired. This should not give rise to a reasonable suspicion of criminal activity. There wasn't any other field sobriety test that had been done. Person had acted nervous and excited, had an odor of alcohol, made inconsistent statements with his fiance, but was polite and cooperative. And the court found that in that circumstance, a slight odor of alcohol, but court said, but not enough to be charged with driving while impaired, although I don't know how you would ever charge somebody with driving while impaired just based on odor. But slight odor of alcohol does not give rise to a reasonable suspicion of criminal activity. So again, I guess you could, the state could argue that says slight, right? That's, it says a slight odor of alcohol. So, that kind of kills everything. But I would submit that is not in and of itself enough of an issue. Let's look at another Supreme Court case, Atkins versus Moy. This is, let me get to it here. Atkins versus Moy, 277 NC 179. This is a 1970 case. This is the Supreme Court of North Carolina. Supreme Court of North Carolina. So our Supreme Court has held that, quote, an odor of alcohol on the breath of the driver of an automobile is evidence that he has been drinking. However, an odor standing alone, and this doesn't say slight, however, an odor standing alone is no evidence that he is under the influence of an intoxicant. This is what happens so many times with these Passover cases. Odor of alcohol, therefore, man, gosh, gotta be impaired. Let's say the stopping officer also, because he can't perform any field sobriety tests or doesn't have any other training, does a portable breath test. Does that add anything to the equation? It doesn't, because under North Carolina general statutes, you are only allowed to determine if that PBT is positive or negative for alcohol. Can't use a number. Can't use a number in the courtroom. Can't use a number in determining whether somebody is impaired, right? That should not go into the probable cause analysis. So if we don't have the ability to use the number from the PBT informing PC, or in terms of being able to articulate, well, here's the reason why I thought this person might be impaired, only positive or negative, it doesn't add anything to the odor analysis. So watch out for this factual scenario, right? And let's just take one more step back here in terms of, does odor of alcohol create reasonable suspicion of is necessary that you can then prolong the stop just based on that odor? No, it doesn't, because we have two North Carolina Supreme Court cases that say odor doesn't create reasonable suspicion, right? But beyond that, this is just a common sense analysis. It is legal to drive in North Carolina as long as you're over the age of 21 with alcohol in your system. Legal to drive. It's illegal to drive impaired. But the odor, and the reason why these cases say what they say, is that odor does not speak to impairment. It only speaks to the fact that the person has alcohol in their system or possibly has alcohol in their system, but it doesn't speak to impairment. So be on the lookout for these type of situations where there is a traffic stop that occurs. Your client is involved in a traffic stop. The stopping officer does not have training in DWI investigation, but smells an odor of alcohol, gets on his radio, calls for a more experienced DWI officer to come onto the scene, and then sits there for 20 minutes, 30 minutes. Not engaging the defendant in conversation a lot of times, not trying to see if they can ask the defendant to walk around, not trying to see if they've got slurred speech, not trying to kind of see if they're standing on their car. They just sit there, normally in their own car, waiting for that second investigating officer to arrive. And using the Rodriguez framework, this is unlawfully prolonging the nature of the stop without additional reasonable suspicion. So make sure that if that odor is the only thing that is being articulated by that stopping officer as the basis for calling another officer to come down, check that out, that if they should have reasonably completed issuing the traffic ticket, that they don't get to then just sit there waiting for 30 minutes at the roadside before a second officer arrives. And there's no kind of like bright line test in terms of how long do they get to hold this person? How long do they get to hold them? For the reasonable amount of time that it would take to complete the mission of the traffic stop. That's it. That's how long they get to hold. So that is, part of the analysis. The other issue would be even if there was additional potential signs and indicators of impairment, let's say red glassy eyes and odor of alcohol, or fumbled with license and odor of alcohol. If those are still pretty minimum, the question then becomes, well, how long do you get to just sit there twiddling your thumbs before a second officer arrives? How long does it take for that reasonable suspicion to be diminished? If that officer is sitting there having a conversation with the client or not doing anything to actually pursue this investigation, that then starts to chip away at, well, does the officer still continue to have reasonable suspicion? Or is that reasonable suspicion getting wiped clean? So that all falls under the investigatory stops approach to fighting this. So what you're arguing in your motion to suppress is that the stop was prolonged unlawfully under Rodriguez without additional reasonable suspicion of any criminal activity. That's the argument if you're going that route. Now, how about the kind of second prong, or the arrest argument? So the other part of the analysis is how long, let's say that there is, again, a little bit of additional reasonable suspicion, and this is similar to what we had kind of just spoken about, but let's say that there is something else going on. Let's say there was an accident and there was a odor of alcohol. How long does that stopping officer get to do their investigation and kind of go through whatever they're looking at? How long before that investigation itself becomes an arrest, becomes what the courts have called a de facto arrest? So one way to arrest somebody is to put them in handcuffs and say, I'm placing you under arrest for driving while impaired. Sometimes Miranda warnings are read. Most of the time they're not, which causes our clients to freak out, right? Because they can get their Miranda warnings read to them. But it's not the only way to place somebody under arrest, to put them in handcuffs and tell them, I'm arresting you for DWI. The courts have said there can also be a de facto arrest that occurs. And once the de facto arrest occurs, now the state is required to show that at the point of the de facto arrest, probable cause existed. not just reasonable suspicion, but probable cause existed. So this is a second or subsequent argument that is based in the kind of probable cause line of reasoning, in addition to the Rodriguez issue. And the main case that was recently decided on this, it's an unpublished case from 2019, State versus Terrell. 2019 North Carolina Court of Appeals case unpublished. So in determining a de facto arrest, State versus, and I hope that I'm going to say this okay, Caruthers from 2009 talks about when a de facto arrest has occurred. Here's when one has occurred. So this is from the Caruthers decision. If the methods used by the police exceed those least intrusive means reasonably required to carry out the stop, the encounter evolves into a de facto arrest, creating the need for the police to show probable cause to support the detention. Whether a particular action on the part of the police exceeds permissible conduct is based on the facts and circumstances of each case. So we'll kind of digest that and go through that as we get into the Terrell decision. But State versus Terrell is, to me, maybe one of the most beautiful cases for the defense that has come out of the Court of Appeals in recent years, because of the fact that this type of situation happens so often. And this is a case that just makes legal sense. It's something that, again, is grossly being underutilized by the defense bar as a whole. And I think it's just not on our radar. It's certainly not on the radar of a lot of law enforcement officers or agencies. So in the Terrell case, I'm just going to go through a brief factual basis. This case is 263 NC App 595 or 822 Southeastern 2nd 17. So the facts of Terrell are: an off-duty police officer was working security detail outside of a nightclub. The officer saw defendant back out of a parking space and strike another vehicle at a low speed. The officer did not notice any damage to the vehicle that was struck. The officer noticed a strong odor of an alcoholic beverage coming from the breath of defendant. Defendant took several minutes to produce his license upon the officer's request. And I kind of like highlighted this because that is pretty unusual. Defendant took several minutes to produce his license upon the officer's request. The off-duty officer interacted with the defendant for close to an hour before requesting another officer to respond. During this near 1 hour period, the off-duty officer testified the defendant was not free to leave. The on-duty officer that responded arrived and looked at the vehicle, took pictures, and did SFSTs with the defendant before placing him under arrest. We've seen that situation so many times, right? Like this kind of turnover to a more experienced officer or a more specialized DWI officer happens all the time. And a lot of the times there are issues with doing that. So the holding of Terrell is that the 1 hour detention of the defendant constituted a de facto arrest requiring probable cause. While the odor of alcohol and the fact that the defendant backed into a car would have given Officer Artieri reasonable suspicion to initially detain him, these circumstances did not without more constitute probable cause to actually arrest the defendant for driving while impaired. So the issue in this case is the court says second officer and the full investigation that second officer did, pictures, SFSTs, looking at the vehicle, you don't get that. You don't get to incorporate that into your PC argument because a de facto arrest had occurred by the off-duty officer prior to the on-duty officer arriving on scene. such that there was a de facto arrest and PC was necessary at the point of the de facto arrest. So let's just kind of read through a couple of the quotes from Terrell. Please read a copy, get a copy of Terrell and read this case. This is a case that you will see play out in real time over and over again in your practice if you handle DWI cases. So language from this Terrell decision. I'm just going to read several sections here. However, even where a brief detention is authorized under Terry, the characteristics of the investigatory stop, including its length, the methods used, and any search performed should be the least intrusive means reasonably available to effectuate the purpose of the stop. And that is the Terrell court quoting again, State versus Caruthers. I don't think I gave the citation on that earlier. It's 213 NCAP 384. That's the Court of Appeals case. In a little bit later, this is the Terrell court quoting the United States Supreme Court in Florida versus Royer. The scope of the intrusion permitted will vary to some extent with the particular facts and circumstance of each case. This much, however, is clear. An investigatory detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. It must be temporary and last no longer than is necessary to effectuate the purpose of the stop. That is from the U.S. Supreme Court, Florida versus Royer, 460 U.S. 491, 1983 case. Furthermore, where the duration or nature of the intrusion exceeds the permissible scope, a court may determine that the seizure constituted a de facto arrest that must be justified by probable cause, even in the absence of a formal arrest. Yeah. Going further on with the opinion in Terrell, in assessing, this is important, in assessing whether a seizure constituted a de facto arrest, reviewing courts should determine whether law enforcement officers diligently pursued a means of investigation that was likely to confirm or dispel their suspicions quickly, during which time it was necessary to detain the defendant. I'm going to read that again because it's so important. In assessing whether a seizure constituted a de facto arrest, reviewing courts should determine whether law enforcement officers diligently pursued a means of investigation that was likely to confirm or dispel their suspicions quickly, during which time it was necessary to detain the defendant. This is the primary issue of this Officer Handoff case, because most of the time, the officer on scene is doing nothing to confirm or dispel their suspicions at all. I mean, not even quickly, but at all. Literally, they will a lot of times tell the defendant to sit in their car. They'll go back to their patrol car and sit there for a half hour while they wait for the second officer to pull up. So this is what pushes the seizure from a Terry investigation into a de facto arrest, or at least part of what does that is the officers just simply not doing anything to confirm or dispel their suspicions quickly. The court goes on to say, and so this is important to note because the state may point this out, and you also want to have a grasp on this, but the court goes on to note, although length in and of itself will not normally convert an otherwise valid seizure into a de facto arrest, where the detention is more than momentary, as here, there must be some strong justification for the delay to avoid rendering the seizure unreasonable. Where the detention is more than momentary, as here, there must be some strong justification for the delay to avoid rendering the seizure unreasonable. And now I'm going to just kind of finish with a couple of the facts of the case and kind of what the court called attention to. So this is straight from State versus Terrell. In the present case, the trial court found that Officer Arteri initially detained the defendant at 11:20 p.m. and held him for over an hour until Officer Sardon arrived at the scene at 12:21 a.m. In addition, the court noted that Officer Arteri had provided no explanation for the nearly 1 hour delay between the time at which he initially stopped the defendant and the time of his call for assistance from an off-duty officer at 12:15. During that time, according to Officer Arteri's testimony, the defendant was not free to leave. Thus, the defendant was detained for nearly an hour until Officer Arteri called for an on-duty officer to assist with the investigation. No evidence was presented that Officer Arteri was actively pursuing the investigation during the intervening period or any other justification existed for the delay. Therefore, we hold the defendant's detention constituted a de facto arrest requiring probable cause. So this is a very valuable case in looking at these situations where there is an officer handoff situation. These officer handoff situations are what we need to really go after. We have to start looking at these cases. We have to be prepared to fight this. What about the burden of proof? So what about the burden of proof to justify a seizure? Well, State versus Reed, going back to State versus Reed, it is the state's burden to demonstrate that the seizure it seeks to justify was sufficiently limited in scope and duration to satisfy the conditions of an investigative seizure. So make sure, and I'm ending with it, right? I'm ending with the burden. So don't follow me. I'm not always laying things out the best way. So when you listen to this podcast, begin with the end. I think this was what Marcus Hill had to say for us. Begin with the end. In this situation, begin at the end of the podcast in terms of what you want to do in your argument. Begin with this burden. From State versus Reed, it is the state's burden to demonstrate that the seizure it seeks to justify was sufficiently limited in scope and duration to satisfy the conditions of an investigative seizure. State's burden of proof. Always start with the burden of proof and point out that this is the state's burden of proof to show that the seizure is justified. And here are the facts and circumstances that show that it's not, and the state can't overcome that despite it being its burden of proof to carry the day when it comes to justification of the seizure. Last point, and there's not any case law that I want to point out on this front. This is just a common sense argument. Let's say that you have an officer that has basically stopped somebody for impaired driving. Smells an odor of alcohol, goes back to the car, radios in, hey, is there another officer on scene? Let me check. We'll wait. 15, 20 minutes later, 30 minutes later, whatever the time frame is, they get a call back that says, we don't have any officers nearby. Don't have another DWI officer nearby, or maybe a DWI officer, highway patrol, or a more experienced officer gets on the phone with the officer on scene and says, look, I can't make it down there for a while. Why don't you just go ahead and place this person under arrest and then meet me down at the jail, right? So sometimes what is meant to be an officer handoff doesn't even happen because there's nobody to hand the case off to. This certainly should fall under this de facto arrest, but if nothing else, please bring up to the court that the fact that the officer is now having to basically go from, well, I can't tell if this person is impaired, I need a more specialized officer, to just being like, well, you know what, I'm just going to go ahead and place this person under arrest and I'll meet the officer down to jail. I have seen this situation a lot in practice. Officer on scene, calls for backup. They're in the, this is why it's helpful to also kind of look at all the body camera, because sometimes you'll see this happening and the defendant never knows that they're kind of waiting on a second officer to come on scene. They get on the phone and say, hey, I can't tell if this person's impaired. Do we have a DWI officer anywhere nearby? take a little bit of time to kind of figure that out. Ultimately, no, we don't have anybody that can come look. And so the stopping officer constitutes an arrest. A major factor in determining whether PC should be present is that the officer didn't feel comfortable making the arrest at the time they made that radio call in. And most of the time, there's no new evidence that happens after that in terms of, if your client gets out of the car and throws up all over the road, well, okay, maybe now this is something where the state could argue that should go towards PC, and the need for a backup officer to come out doesn't make any difference. But if they just are going on the initial observations, and at that point they couldn't tell whether or not the person was under arrest and they're asking for backup, that should be very hard and fast evidence that probable cause to arrest does not exist, because the officer didn't feel comfortable, but then basically ran out of options for somebody to come take over the case. So a lot of information, a lot of cases to look through. This situation comes up all the time, partially because officers don't realize it's an issue, partially because they don't get called out on it by us, and then partially, and more, it's becoming part of the plan. The plan is, hey, we've got all these specialized DWI officers. If you, the stopping officer with no specialized training in DWI, get somebody that you believe possibly is impaired, and that possibly being impaired is basically they have an odor of alcohol, you call the specialist. So more and more, it's becoming part of the training. We have to be ready for these type of cases, because we potentially have a Rodriguez issue in terms of the length of investigatory detention. So the seizure is bad from a reasonable suspicion standpoint, or we have a investigation that has now turned into a de facto arrest requiring probable cause, and probable cause does not exist. So take this information, digest it, read it. Got a question? Call me about it. Discuss a case with me. Happy to go over that with you and get after it in the courtroom. Look forward to speaking with you next time.
If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.